Bashan, why is nobody in jeans? It's rodeo. Oh, okay, I'm just shocked by that. Usually the prosecutors come in their jeans. Victoria Lopez, like your hair. Hello, how you doing this morning?
Hi, ma'am. How are you?
Oh, I'm doing great. It's Monday.
Yes, ma'am.
Guess what? Only good things can happen.
Yes.
At least we should think that.
Yes, ma'am.
That's what we're hoping for.
So before we go on the record, have you all reached an agreement on bond amount?
We have not, Your Honor. State and defense would make their respective recommendations.
All right, court is calling cause number NM 743-783 State versus Victoria Lopez. Could I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Doug Campbell for Ms. Lopez.
And are you Ms. Lopez?
Yes, ma'am.
All right, we're hearing a motion to set bond. State, do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
Judge, I probably am just going to go with argument.
All right, so defense, what are you requesting?
Bond amount is $7,500.
All right, and defense, what are you requesting?
Obviously less than that, Judge. My client was out on bond. She, for a possession case, it was less than a gram. She picked up another case. Her bond was surrendered. And she would like, I mean, we can't get that reinstated, but she would like a bond closer to the $1,000 level. She will appear for trial if we have to appear for trial.
All right, the $7,500 bond, did she make that bond previously?
The 7,500, no, it's never been said. She's remanded without a bond right now.
So on this
But she
case,
did make the $1,000 bond and she's made the $1,000 bond on the other one.
all right, so this was previously $1,000 bond.
Yes, Judge.
All right, and the
Your Honor.
new, yes,
I apologize. If we're talking about night mag numbers C43783,
74383.
yes.
the previous bond amount set on December 24th of 2023 was $5,000.
I'm sorry, Judge, you're right. You're right. I apologize.
All right, so that was $5,000 on this case, the instant case,
Yes,
and she made that bond.
she did make that bond.
All right, then the next question is the case that she's alleged to have committed, the new case, what's that cause number?
That one is 2024 PF 27235.
And what is the bond amount on that case?
I want to say that's $1,000.
And what is the offense?
Possession less than a gram.
And what is her criminal history?
Judge, the state probably has a better picture of that, but it looks like she's got a theft out of County Court 13. Excuse me.
Well, Your Honor, Ms. Lopez has 4 current active cases, 2024 PF 27235, 2025 CC 00.
Wait, just one second. So if you could list the open active cases she has for me, what the offense is and what's the alleged offense?
Possession controlled substance PG1, less than a gram. Offense date alleged offense date December 12th, 2024. Theft of property greater than $750 and less than $2,500 with the same offense date. Theft of property with less than $50 with previous conviction. Offense date December 23rd, 2003. And the instant case with the same offense date.
All right, so the case that's before me today, the alleged offense date is from 2023?
Yes.
All right. So here's my question. We are now in 2025. Why isn't the laboratory results in for this case? And why shouldn't I give her a PR bond on this case if there's no lab results? And when are the lab results coming? Because I'm shocked that we have a 2023 case and there are no lab results. I can understand the possession less than a gram, that's December 12th, 2024. And Bashan, you know what I find shocking? Bashan, why is nobody in jeans? It's rodeo. Oh, okay, I'm just shocked by that. Usually the prosecutors come in their jeans. And I'm like, it's rodeo. I guess we're waiting for the rain. Oh, I received a call that it is raining in some parts of San Antonio right now. All right, who's here on Deborah Aguilar? Yes. Are you ready, counsel?
Yeah, approach, Your Honor.
Yes.
Good morning. How are
Good
you?
morning. Are you all ready to proceed?
No, Judge. Judge,
There's
there's
a
a,
new case and there's nothing on it yet.
it's an ag robbery. It's about Less than a month ago. It happened on the 14th of January. It's one thing of many things of that, Judge, but obviously defense counsel doesn't have any access to any discovery, and I don't have any discovery on Bear Pick at this point.
All right, so how much time are you all asking for?
I would ask for at least 30 days, to evaluate the ag robbery and at least get some discovery to defense counsel on that subject so that they can evaluate the case.
All right, Norma, set this for, you guys are doing jury selection on McIntyre on the 31st.
True. Yes, Judge. And that should last at least a couple weeks, probably. Well, not the jury selection, hopefully.
All right, Norma, set this the week of April 14th
That should be
for a
fine, Judge.
contested hearing. And if it's not contested, it's not contested.
Yes, ma'am, I'll do it on the 14th.
Thank you.
All right. Ms. Abrams, Aguilar is coming back on April 14th for a contested hearing and defense, Mr. Schaefer. Hi, I'm assuming do you have any objection to that date? All right, thank you. Okay, all right, thank you. All right, could I see the file on Michael Ogden, please? Yes.
Mr. Ogden's dismissal has been signed and we have been served. May he be excused for the day?
Yes, could you have them come up, please?
Yes,
All right, thank you.
Mr. Ogden himself.
Yeah. Yes, thank you.
Mr. Ogden.
Hello, Mr. Ogden.
Good morning, Your
Good
Honor.
morning. So my understanding is the state has decided to dismiss your case. They say they're dismissing it in the interest of justice and that you agree that you're going to forfeit the weapon. Is that correct?
Yes, ma'am.
All right. Good luck to you. Thank you for always dressing appropriately for court. Thank you.
Thank you,
You're
Judge.
welcome. Michael Warner.
Good morning, Judge.
Good morning.
Michael's president, I have some further, I have an offer of.
All right.
They would agree to leave open 1 second.
Okay. Just 1 second. Let me pull up his case. And so it shows the last thing I have for him is there was a bond forfeiture.
Yes,
So-
Judge, there was this court date in October.
Mhm.
We took care of that a couple of weekends ago. We Came in on the following
Got it.
Monday and you denied on I side.
Ah, okay. All right. So in this case, you have all discovery
Yes, Your Honor.
and was an offer tendered.
Yes, Judge.
Sir, how old are you? I'm sorry, what?
35 years old.
All right, Ms. Ferguson, reset this for 3 weeks for plea deadline date. And you need to make sure you're on time for court. You were late today.
It would be March the 3rd.
All right, your plea deadline date will be March 3rd.
Okay,
Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
thank you, Judge.
Thank you.
Miguel Ayala.
Can you have this file pull, please? 2024 CR 00871. Yes. Oh, it's not on the docket today. I don't think it is, at least. It's 2024 CR 00871. And Norma, on that case, it's Sanhydric. Can you let the attorney know that the case has been dismissed? 2024 CR 00871. Counsel, are you ready?
I am ready, Judge.
Was a PSI done on this case? Oh, defendant waives PSI. Thank you. All right. Court is calling 2024 CR 01271, State of Texas versus Cody Kraus. Can I have parties announced for the record for the state,
Opinion for the state of Texas?
for the defense?
Mark Darling for the defendant, Your Honor.
And are you Cody Cross? All right, both parties agreed to waive the PSI. Is that correct, state?
Yes, Your Honor.
Defense, is that correct?
Yes, Your Honor.
All right, according to your plea bargain agreement, the state was proceeding on count 4 only. State waived count 1, 2, and 3 without objection. You waived the PSI. To count 4, you entered a plea of no contest. According to the plea bargain agreement, punishments be assessed at a cap of 6 years in the prison. There's a $1,500 fine. The state opposes your application for deferred adjudication. The state is silent on your application for community supervision. This is to run concurrent with 2024 CC 742862. The state is taking in consideration 2024 CC 742860, 2024 AL 004803, and there's to be no contact with the complainant.
That's not an issue now.
All right. So are there any witnesses, state you're opposed to his application for deferred adjudication?
Correct, yes, ma'am.
And why are you opposed to the application for deferred adjudication?
Given his criminal history, Your Honor, the defendant, even as a juvenile, has many assault cases, a lot of them involving the same victim. The cases that are being run concurrent NTIC as well, include the same victim. So given the defendant's history for violent offenses, we are opposing his application for deferred adjudication.
All right, and what is his criminal history?
So in 2012, he had 3 juvenile ABI charges. In 2022, he had a burglary of a vehicle charge that he did 1 year of deferred adjudication on.
And did he successfully complete that?
Yes, Your Honor.
Okay,
He has one of the 2023 ABI cases that's currently pending that's part of this plea deal. The terroristic threat in 2024 that's currently pending as part of the plea deal as well. Another 2024 ABI that's pending as part of this plea deal. And he's got some out-of-state charges from Oklahoma for DUI and possession of a controlled substance that are currently still pending in that state.
all right. Any witnesses state with regards to your opposition to deferred adjudication?
No, Your Honor.
All right, defense, any witnesses?
Judge, I'd like to call Ivy Regalado. She's present today for about 5 or 10 minutes of testimony.
Sure, sir. Excuse me, Mr. Kraus, will you step over there, please? All right, you can come forward. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Ivy,
All right, and could you spell your last name, please?
Regalado.
All right, I asked you to do that for the court reporter and also for myself. All right, defense?
Ms. Regalado, do you know Cody Kraus?
Yes, I do.
And how do you know him?
I work for Sam Ministries as a rapid rehousing case manager, and he is one of my clients.
And so is it fair to say that Mr. Kraus was seeking housing through your entity?
Yes, Cody Cross is on my youth program, and he was homeless, and we have been working together to stabilize him financially, education-wise, and housing-wise.
And what's your understanding of his housing situation right now?
Right now, if he was able to get probation, I would still be able to house him. Because of his age, he is priority on the housing list, because he is under the age of 25. If he was, if he did serve more time and did not get out until he was 25, the chances of him getting housing with any kind of assistance is dramatically reduced.
Okay, and what is his history that you learned during the process of trying to get him housed?
Cody has extensive childhood trauma that has been unresolved. I have been working with him to get into counseling and to take anger management classes. I do understand that he has been in and out of the system for a very long time. But working with him and learning more about him, I do believe that he's not given a fair chance and has not been given a fair chance. And I would like to continue working with him to get him out.
Okay, and when you say he's been in and out of the system, are you talking about as a CPS foster child?
Correct, yes.
Okay. And did he qualify for housing before his extended incarceration pursuant to the pending charges? Did he qualify?
Yes,
And your testimony then is that he still qualifies should he be able to get out?
yes. If he was able to get out, he could continue on my caseload for almost another 2 years, which would help him go to therapy free of charge, get housing free of charge. He could go back and get his GED and pursue further education, also free of charge with working with our organization.
And did he indicate a willingness and desire to participate in your organization except for purposes of the housing?
Yes, he did.
Okay, and then does Mr. Kraus have a CPS case wherein he's a parent right now?
Yes, he does.
And does he have obligations under a service plan that he needs to complete in order to maintain his parental rights?
Yes, he does.
Okay, would he be able to do that if he was incarcerated?
I know he did not.
Judge, I'll pass the witness.
All right, any questions?
Yes, a few questions. Morning, ma'am.
Good morning.
Now, you testified earlier about your interaction with the defendant, Mr. Cody Kraus. Could you please testify again as far as when you first came into contact with him?
I believe it was April of last year, so I've been working with him almost a year. And he was referred to me by my supervisor.
Okay, almost 1 year of contact with you.
Yes.
Were you aware of any of his history prior to that time?
We have some case notes when we get the referral, but most of it is just one-on-one conversations with him.
Were you aware of any of his criminal history at all?
Yes.
Okay, and does his criminal history play any type of role or decision making into his applicability for housing?
Absolutely.
Okay. You mentioned that you have, or that he's going through counseling, is that correct?
Yes.
Okay, what kind of counseling is he going through?
So we had put in the referral right before he got arrested, to do, counseling and psychotherapy. And this can be done virtual or in person,
Okay,
with UT Health.
has he been in compliance with his counseling?
He has not been able to because he's been incarcerated. I will just say that the referral was, voluntary. It's not mandated to stay part of the program. He chose to do that by himself.
Now, are you aware that even after you come into contact with him in April, that he's committing crimes in September?
Yes, I am.
So despite that, that's again not playing a part in your decision for housing on him, correct?
Correct. So when he was released, when he went back home, the apartment that we had worked together for him to establish was only in his name.
Okay,
I understand that there was a violation where he was not supposed to get in contact with her, with the defendant. But that housing was just for Cody. I'm not making excuses, I'm just offering an explanation. That the other person was not supposed to be in the household. But we were working on, because she would not move, we were working on getting him rehoused somewhere where she did not know the address to, so that way they would not have contact.
Yep.
And so if he was released on probation, we can immediately house him somewhere else to where, again, there would be no contact with that time.
no further questions, Ryan.
Any further questions?
Pass the witness, Judge.
All right, I have a few questions. So when did you start working with him? What's the month and year?
April 2024.
All right. And when you began working with him, was he already in this relationship?
They were on, yes,
All right, and were you aware of that?
yes.
And when you were working with him, was there any work done related to any relationship issues he had with the complainant?
We had done the housing separate from her, just because they were having some issues. Cody had decided just to get the apartment by himself, so that way she would have, his housing could be stable. When that happened, a couple months later, if that, she had stated that she had nowhere to go with their children, so he let her into the apartment. But she was never on the lease. And we were just trying to work it out through going to therapy to see if they were going to work it out or if they were going to if she was gonna leave.
All right. And then do you remember what month or of when she moved back in or when she moved in?
May, June, I'm not too certain.
All right. And did you ever do any therapy inside the home?
Me,
Yes, or anyone else?
so we do, at least bi-weekly visits. And so I would go in, we would talk about his goals. Even though she wasn't my client, she was able to be part of the goals because she was on the housing. But I just worked mainly with him because she just didn't really want to do anything. So we did like biopsychosocial assessments, mental health assessments, just to see where he was at mental health wise. And I gave him resources like the UT Health partnership that we have, and he decided to take advantage of that. A little bit too late, but he did volunteer to put in that referral.
All right. So you just said something about housing. So she's on housing, is that correct? But she's not supposed to be in that house.
So the way that our program works is we have one client. So he was the one that got pulled for housing. If the kids come or a spouse come, then they're automatically able to get resources from us, but he would be the main client. So if she chooses not to do any services like the GED or employment, then that's something that's just out of my control. And I would really just focus with him because he's the main one.
Okay. And what type of services are you offering him now if he were placed on probation?
And so if you were placed on probation, immediately we would try to house him. The goal is always under 30 days, but we can make that happen in 24 to 48 hours with the landlords that we work with. And from there, we make a housing goal. So if he wants to go back for his GED, we can set him up with that. We also partner with Goodwill to get him employed, work on a resume, work around his criminal background. And we also work with UT Health for the counseling. Sorry, I'm blanking. But we have resources for everything, and the goal is to, after the year to 2 years, you can be in a place where you can get mental health help, you can get physical health. So we can help them with SNAP benefits, we can help them get Medicaid, so we can go to the doctor.
So does he have mental health issues?
I would say yes,
Does he have any drug issues?
prior, yes.
And prior, what was that?
From my understanding, just weed, not just weed. But I was never, nothing else from my understanding.
All right, if the court were to grant him probation as a part of his housing, could you ensure the court that you would not allow other persons to stay in that house?
Yes, it is. We work with the landlord, if there's, the landlord sees somebody, or if I see somebody, because we can just be dropping visits. We can talk to him about it, we can talk to the court about it, which I'm assuming there would be something in place. But from the conversations that we've had since getting arrested, because we've had a couple, I do think that he genuinely understands the severity of, while you were in that mindset of trying to do the right thing for the right reasons, look at where it's landed you, and I do understand that, I do think that he understands the severity of, this cannot happen again.
All right, so here's the problem. I've just been informed by the state that he has out-of-county issues as well, and they're still open. So how is that addressed? Because he has out-of-county cases as well.
I can talk to my supervisor. I know we have worked with out of county. I haven't had that experience with a client, but I do know that we work with other courts to resolve that so they can keep their housing.
All right, and if the court were to send him to prison, would you all still be able to work with him when he was released?
No, he would have to get back on the waiting list. But again, there's priority given to ages 18 to 24. Just because so many have just aged out of foster care. That's my grant. So he would have to just go to the general one, which is about a 5 to 7 year waiting list right now. And so he would not be eligible just to get back on the services because he would age out from the program.
All right. And so how long do you have this placement open for him?
Right now, we're just waiting for a decision from you. But we can, if he was released, we could keep him up to almost a year and a half now. From now, because he's only technically housed for about 5 to 6 months, and we can keep him open for 24 months.
All right, so here's the problem. I don't know what's going on with his out-of-county cases. I don't know if he has a warrant for that or not. So he may not be released. So I'm just trying to find out if I were to grant him probation and he's not released from the other county, if they pick him up, how long would the opening last for him? Because if I were to grant him probation, once he's released from custody, I would want him immediately in the program. So is that possible?
Yes, so as long as we know that there's updates, as long as we have updates, so even me coming here today, that's something that I can place note that he's still my client and we can keep him open. And that doesn't go towards the year and a half. So as long as we know where he's at, what's happening and there's updates, then we can keep him open so that the day he's released, he has somewhere to go.
All right. Thank you so much for coming down.
Thank you, John.
Oh, I'm sorry. Any other questions?
No, Your Honor, thank you.
Maybe just one question more, if that's
Sure.
okay. You mentioned earlier that in your opinion, you feel he's got mental health issues. Is that correct? And have you had any training or experience being a mental health professional?
And so I have trauma informed, I have my trauma informed care certificate. We do extensive training with childhood issues, with ACEs, we do biopsychosocials. And then from there, we take it to a professional. But I think anybody with that kind of childhood and those kind of issues.
I understand. But have you ever made a mental health diagnosis yourself?
No.
Okay. No further questions, Your Honor.
All right, is there anything else?
I just wanted to call Mr. Kraus for a second, Judge.
All right, thank you. All right, so before you call him as a witness, I don't know, he may say something that will make me make up my mind, or he may not. Or whether or not to place him on probation. Two things I need to know. Somebody needs to contact whoever his attorney is out of county to find out what level those DWIs are and exactly what is going to be happening with that. Because if they are, sending him to jail, if it's a misdemeanor, or sending him to prison, then all of this is for naught. So I need that. And if somebody wants to call the complainant as a witness and have them zoom in, that would be appreciated.
Your Honor, we have reached out to the complainant and she's not getting back at us, so I don't know that that's gonna be possible for the state's end.
All right. So counsel, how long will it take you to find out who his attorney is and what is happening with the misdemeanor cases or felony cases that are in that other county?
Well, that's largely dependent on the quality of information that the state can give me so I can begin my search. I'm not
Let me
aware
help
of
you with that.
these.
Come forward, sir. Come forward.
Yes.
What county are your other cases out of?
It's Oklahoma City. They had, when I first.
No. Listen to my questions. What county are your cases out of?
Around Oklahoma?
All right. Do you know your case number?
No.
Do you know who your attorney is there? All right, so we're off the record. This is the court's suggestion that you call Oklahoma, the county that he's out of, get in touch with the public defender's office, because I think they have a public defender there, and find out what is happening with his cases there.
I can do that, Judge.
Because my hands will be tied depending on what is happening there. So how much time do you want, counsel?
Your Honor, I was probably about 3 days. I'd like, if I could come back on Thursday, that'd probably be good, or.
All right, Ms. Ferguson, on this case, if you can recall it for Thursday. And to your witness, are you able to come back on Thursday? All right, so if you can be back here on Thursday, that would be great. All right, is there anything else?
Nothing from the defense, Judge.
Your Honor, may
Nothing
I
from the state.
ask you?
No, that's probably not in your best interest. All right, so we'll be back on February 13th.
All right, thank you, Judge.
You're welcome.
Looking beyond.
Yes.
Judge, Mr. Smith, I'll be on Smith, Jordan.
Yes.
It's been brought to my attention that he's been a lifelong sufferer for schizophrenia. I was
All right,
unaware of
Is
that.
he here?
He is, he's in custody.
All right, Mr. Smith, come down. So we're here on a motion to revoke.
That's correct, Judge. And he also has a new number 1 in here and a new number 1 on 12. I wanted to have a mental health evaluation done with him before we proceed, just so we're all on the same page.
All right, do you think he's incompetent?
Judge, I'm not saying that. He's just taking, it just come to my attention that he's been a lifelong sufferer of schizophrenia. And I wanted to see if you could speak with a physician and see where we are on that. So how that may or may not affect the way I must move forward with this.
Well, I mean, the only issue is if he's incompetent, then we'll have a competency. If he is competent, this is either going to be a contested hearing and you can bring in whatever mitigation information you would like.
Understood. But I still need to have that evaluation done, Judge. That's what I'm saying. We don't have that right now. We'll get there later. I'm asking for a little time for him to be evaluated, Judge.
But I mean, he's competent. So what are we, if you're asking for something for mitigation, that's something completely different as opposed to competency. If you're saying he's competent, but he has prior mental health issues or still has mental health issues that he is being medicated for, then you can present that to the court and I'll consider it as mitigation, or maybe that there's something else that needs to be done.
Understood, Judge.
Okay. All right. Thank you. All right, sir, just have a seat. So you all want to confer?
I've been conferring, Judge. He was supposed to have had a mental health evaluation done as part of his probation with your court. That was never done.
Okay.
So I was hoping to get one done while he's in custody.
No, I can hear the violations and see where you all want to go with that. Otherwise, it'll be set for contested.
Okay, Judge.
All right, thank you. All right, Christian Garcia. How's it going? All right, I cannot complain. You too?
Like she has to turn herself in.
Neil, you're becoming a renaissance man.
I don't know if that's a good thing or a bad thing.
It's great.
It might be.
Let me know when it's in.
You know, it's rare that you have Renaissance men or Renaissance women these days. All right, so you all are here to modify bond conditions, correct?
Yes, Your Honor.
All right, let me find him on the docket. All right, I found it. You have a lot to live up to because you have 4 names. I always say, anytime you have more than 3 names, it's royalty, right?
Yeah.
Thank you for dressing appropriately for court.
Thank you, Your Honor.
All right, so let me see. All right, so the issue is with the GPS, and I'm assuming you're asking for it to be removed?
No, Judge, just to track them.
All right, any objections to tracking?
Yes, Your Honor.
All right, we'll go on the record. Court is calling 2024 CR 0087173 and 2024 CR 00812 State versus Christian Allen Reeves Garcia. Could I have parties announced for the record? State,
Jason Garahan for the state, Your Honor.
defense?
Raymond Martinez.
All right, so we are here. This defense is requesting that the defendant's bond be modified to tracking only, and state you have objections?
Yes, Your Honor.
All right, so defense, why are you requesting tracking only?
There's several things. Number one, Mr. Garcia has been on bond for a good while. He's had no violations. He was originally on full house arrest for how long?
All right, if you're gonna call him, I'll need to
No,
put him
I-
under.
I just,
Partial, is that correct?
he's on partial now, but he was on full house for 3 to 4 months before he moved to partial. The court moved him to partial so that he could go to work. His dad found him work, and he's been doing that. You've also given him permission to go to church on Sundays, but he's got a curfew. The issues that Mr. Garcia is running into now, he's got some health issues. His doctors told him he has high cholesterol and borderline diabetic, so he's got to attend to medical appointments.
All right, see, you know what? High cholesterol, diabetes, we all, and when I say we all, I include myself, we gotta start eating better and exercising more. It's hard. I'm surviving off of oatmeal.
You're making my point for me, Judge. One of the things he
Yes.
wants to do is to exercise for purposes of addressing that. His primary care physician has also recommended that he apply for Social Security disability for some
Well,
other.
people, do we not exercise in our backyards anymore? That's what we would do growing up.
No.
I mean, do
You
we?
see gyms at every corner, Judge.
Everybody,
Obviously, we're not.
he doesn't need a gym. Do some push-ups, do some weight resistance.
Well, Judge, there's been studies done about how when you get into an atmosphere where everybody else is also doing that, it kind of pushes you and motivates you. They've done studies on like when bicyclists are riding by themselves versus when they're in a pack. It's the synergistic effect of everybody moving together. And so that's why there's so many
Well,
gyms.
who lives in the house with him?
Parents.
See, we can make this a group thing where everybody exercises.
Yeah. And so getting around, and he's also trying to go to college, Judge. The FAFSA financial aid being held up because of these cases, but they're trying to work through that.
See, he's becoming a Renaissance man.
He definitely is, Judge.
Okay.
And he's been, I dare to say, perfect on
All
pre-trial.
right, so here's my question. Because sometimes I try to find a happy medium, if we can come to a happy medium. So, state, would there be any objections to allow tracking with a curfew? Did you all think about that?
He has a curfew now, Judge. It's very early. That's like 6:45, isn't it?
Yes. But I mean, he's on partial. He's only allowed to do certain things. So
Right.
I'm saying tracking with a curfew. Did you all discuss that?
We did not, but we're
Y'all wanna
certainly
just-
open to that. I think the state's just opposed to
All right.
tracking in general.
Well, you all want to discuss that? Because I think part of the issues, we can go off the record. I think part of the issues based upon his charges is sometimes, you have people, they need to be in the house before the street lights come on, because people tend to act crazy when street lights come on. So I don't know if that's something you all have considered, if that's something you want to consider. But I will tell you, counsel, based upon his charges, I'm not inclined to do tracking only. So if you all want to do tracking with the curfew, then the court will consider that. But just a blanket tracking, I'm not inclined to do that based upon his charges. So if you all want to discuss that,
Yeah, I can discuss it with defense counsel.
all right, thank you. And then if you all could, because I know things happen on the weekend, maybe tighten up the curfew time on the weekend. And then maybe during the week, it's something different. But discuss. Thank you.
May I approach, Judge?
Yes.
Well, Mr. Smith, if we could get him set for a contested, I think that's the best way for us to get this resolved.
All right. I do contest this in 2 weeks.
As long as it's not after the 27th. or before the fourth. I've got some obligations I have to take care of through my wife. I'd be in big trouble.
All right, who's here on John Philip D. McCarter?
Morning, Your Honor, David T. Arena.
Good morning. How's it going?
Good to see you.
You too. All right, court is calling. And I'm sorry, counsel, if you are going to speak, if you'll move down to that end. All right. Court is calling 2024 CR 012474 State versus John Philip D. McCarter. Can I have parties announced for the record? State,
Megan Galloway for the state.
defense.
David T. Arena for Mr. McCarter.
And are you Mr. McCarter?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is compliance with discovery. Is this an application for deferred adjudication or community supervision?
For community supervision, Your Honor, not eligible for deferred.
So, Mr. McCarter, did you sign the document entitled Application for Community Supervision?
Yes, Your Honor.
And did you review that with your attorney?
Yes, Your Honor.
So the record is clear. The court has an application for deferred adjudication as well. Do both parties agree that your agreement is for community supervision only?
Yes, Judge.
Yes, Your Honor.
All right, so you understand, sir, that there's no application. Today, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
I do, Your Honor. Just for the court to take judicial notice, it is his first sin. He's never had one of these before. He's got a clean record. And
Everyone, please whisper.
and he's been extremely remorseful, which is difficult for this judge to see, but I've done a few of these and he's definitely taken it seriously. So we would ask for an ankle monitor instead of incarceration, but we leave that, of course, up to Your Honor.
All right, so how often have you been drinking?
I haven't had it since the incident.
Mhm.
I have not had a drink since the incident.
All right, and how often were you drinking before the incident?
Not
just because this is DWI. The legislature has mandated everybody who's on probation, you can't drink alcohol, whether it's in your home, at a cookout, it is not allowed. In this court, to be successful on probation, communication is key. If there is an issue, you need to let your probation officer know. If you feel you're going to take a drink, pick up the phone, call your probation officer. Because you need to figure out while you're on this probation, what helps you maintain your sobriety. You understand?
Yes, ma'am.
All right, if you have an issue, let probation know. If you feel they're not addressing it, you can always come back to court and
Thank you,
address it
Your
with me. All right, thank you. Thank you for dressing appropriately for court. Just remain in court and probation will go over conditions with you.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.